ALS, Association of African Labor Law Societies, as well as ILAW, the International Lawyers Assisting Workers. So since January, we've been looking at a couple of the fundamental ILO conventions. And what's informed this webinar series is the amendment of the laws, the labor laws in Nigeria in 2010, which empowers the courts to apply international labor standards, international best practices, as well as ILO conventions directly in Nigeria. So we realized that despite this change in law, the knowledge and awareness about international labor standards is still relatively low amongst both practitioners as well as employers and even some employees in Nigeria. And we thought this webinar series would help to fill that knowledge gap. We started in January by looking at just what exactly is this ILO and how are these conventions made. And then we moved in February to look at the conventions on forced labor, as well as abolition of forced labor. In March, we looked at the conventions on freedom of association and the right of labor to unionize. In April, we looked at the discrimination conventions. And in May, we looked at the conventions on the minimum age and the worst forms of child labor. Now, we didn't have one in June, but we're having one now to look at the conventions on occupational safety and health at work. Our moderator is Adeola Agumbiade, who is a senior associate at the Nigerian firm of Bamuwa and Ikodalu. Adeola would introduce our esteemed panelists. So I'll hand over to Adeola to introduce the panelists and to get the webinar going. Thank you for attending and listening to me.
Thanks, Shehu, for that very warm introduction. So just like Shehu had said, today we're going to be reviewing two conventions, right? Which are the conventions on OSH, occupational safety and health in the workplace. So we're specifically looking at the convention 155, right? And then which is occupational safety and health convention 1981. And then the second convention is the convention 187, which is the promotional framework for occupational safety and health convention 2006, right? So by way of very brief introduction, this convention sort of just provide broad principles, right, that both employers and governments working collaboratively should sort of consider when it comes to safety and health issues at work. And they're very quite preventative in the way that they're structured, which is that even though we know that accidents would happen from time to time, but as much as possible, what are the processes that ought to be put in place, you know, in terms of maybe for industries that use machineries and what have you, you know, what are the processes that are meant to be in place to sort of, as much as possible, minimize health and safety issues. Again, interestingly, the convention doesn't just touch on safety and health issues when it comes to the physical environment. It also touches on, you know, it goes as far as touching on what you should expect when it even comes to ensuring some sort of protection when it even comes to mental health, right? In terms of what employers, government are meant to look at when it comes to work processes. Anyways, we have our panelists here with us today who are going to do justice to the provisions of this convention and would also explore some of the issues, that are sort of topical when it comes to examining these conventions. So we have, in no particular order, we have Dr. Bamu, and then we also have Mrs. Wosu. So by way of very brief introduction, Dr. Bamu was born and raised in Zimbabwe. She holds a LLB, LLM, and PhD from the University of Cape Town in South Africa. She's currently the president of African Labour Law Society. She has consulted for international ILO and the HSDC on various projects. She has also worked with various universities, including the University of Cape Town, University of Western Cape, as a researcher, lecturer, and external examiner. She was previously at WIGO, and during her time there, she had worked with the International Domestic Workers Federation to develop the toolkits on domestic workers and Convention 189, which aims to make the ILO Convention concerning decent work for domestic workers a reality. Bamu is also the project lead of the Administrative Justice Project, which promotes due process in decision-making that affects the livelihood of street vendors and waste speakers who work in public spaces. In addition to writing several publications, BAMU has provided technical support to government and worker organizations that have submitted reports on compliance with ILO or other submissions in legal reform processes. BAMU is currently based in Washington, D.C. Dr. Bamu, you're welcome. So we move to Mrs. Wosu. Mrs. Wosu is currently the head of the legal unit in the Lagos region of Nigeria Social Insurance Trust Fund. She has over 23 years of post-qualification experience in both the private and public sector, and from the banking, legal practice, and public administrative sectors. Her academic qualifications include LLM from the University of Lagos, EL from Nigerian Law School, Abuja, and Bachelor of Law from University of Nigeria, Enugu campus. She's a member of the Nigeria Bar Association and a senior member of the Chartered Institute of Public Diplomacy and Management. She joined the NSITF in October 2013 and worked as a compliance and enforcement and claim officer before joining the legal unit in 2019. Mrs. Wosu, you're welcome. So to move further in the webinar, we'll be inviting Dr. Bamu to make a presentation on the conventions, and then we move on from there.
Okay, good afternoon, everyone. Good afternoon to our president of ILAN and all colleagues, all protocol observed. Thank you for this opportunity to share a bit about occupational safety and health, or occupational health and safety, as I've always called it. So just to correct one thing about the introduction, I still work at WIGO. Maybe, I don't know, the way that the bio read might have looked like that's not the case, but that's still my position. And I work a lot on occupational health and safety issues. I will share my screen. Wow. Apologies, it's like I'm trying to find, accessing. Okay, I think this is it. I'm just trying to open the window. So, I have a picture of of a street trader in the front. It's not accidental, because one of the arguments that I hope I'll make is that issues of occupational health and safety are for all workers. And so we should get to a situation, particularly in the African context, where we see the likes of a trader being able to access the occupational health and safety protections. So my presentation is as follows. It's failing to just show me speaking here. But my presentation will cover occupational health and safety standards and looking at what the logic is and the context in which they arose. Then I will try to just give an overview of the provisions of Convention 155 and 187. And I'll talk a little bit about ratification and implementation in Africa and look at the key challenges in an African context. So I'll try to keep to time. I think there are some things that I can come back and discuss in a bit more detail. So the issue of OHS or OSH, in ILO context, they speak of OSH. So my apologies, you'll see both of them are mentioned as we go. It is based on the principles that were developed to manage risks generated by a galloping industrialization, which began in the 1800s. And so this is very, very important, as we shall see, because it shapes the way that laws have been drafted, the way that they are presented, the way that they're implemented when it comes to OHS. Then I'm going to talk about the principles of liability. And by that, it's really about the fact that where does a person's liability, typically the employer, arise in relation to occupational health and safety? Why should somebody be liable? The first is that there's an assumption that there's a contract of employment. So if I'm an employer and I have an employee, the control, the relationship of subordination puts the employee in a position, or the worker in a position, where they're supposed to be protected against any risks that will arise in the context of the work that they've been told to do. Then, secondly, the other issue relates to the employer's control over the workplace and how that is a factor. Because if I am in control of a factory, if I'm in control of a farm or an office, and people are working there, then I should be responsible for ensuring that their safety and their health is not at risk. So another thing that we need to think about is, what is the main objective? And I take this from Convention 155, which is the Occupational Safety and Health Convention, which we'll be talking about. And the main objective of OHS regulation, OHS protection, is to prevent accidents and injury to the health arising out of, linked to, or occurring in the course of work. So health-related accidents, injuries that arise in the context of work, or that are linked to, or that occur in the course of work, are supposed to be prevented. Then secondly, the point is that we should be minimizing them. So how does the employer prevent these accidents? How does the employer prevent these injuries? By minimizing the causes of hazards that are inherent in the working environment. So the typical things that you expect to find in the working environment. And that also speaks to, you know, the context of the workplace itself, the processes involved, the equipment that is used, and such things. So what is a person exposed to in the normal course of doing the job that they do in the place that they do? And this has lots of implications for how we think about it. Okay, so typically where we are coming from is this idea of like the industrial workplace, the place where everyone goes and they're working for an employer and so on. And where does it come from? If we look at occupational health and safety, it's a product of history. So it arose, these things in the picture. I don't know if you can see, but they're vehicles. So these were amongst the first vehicles that were produced. They're called the Tin Lizzie, produced by Henry Ford, and it's looking at a time that we call the Fordist era, a time of mass production, a time of hierarchical organization, where things, there was a division of work that was very, very precise, and each person was doing a particular task. Collective organization came about as a way to countervail or respond to the fact that the employer with the money has power. And so the collective voice of the workers became very important. It's a context in which, the welfare state provided for social protections, and it's a place where this idea of standard employment, which is full-time employment, permanent employment, and so on, arose. That's where the concept and the notion of occupational health and safety, or OSH, sort of is coming from. And it is where we as African countries that were colonized get the main orientation of our occupational health and safety laws, because it was designed to operate within those workplaces that they sort of grafted or created in the context of African economies. And that's very, very important. So we've got 2 conventions and we have 2 recommendations. Convention 155 of 1981, the Occupational Safety and Health Convention, has an accompanying recommendation. That's not a mistake, it is recommendation 164. Why does it have its own number, the accompanying recommendation? Simply because there are times when in the ILO processes of standard setting, there's no consensus to set an international convention. And so the compromise becomes the adoption of a recommendation. We can think of the recommendation on the employment relationship, which is, I think, recommendation 190. We can think of recommendation 204, which I work a lot closely concerning the transition from informal to the formal economy. Those are standalone recommendations. And so even though each convention must come with its own recommendation, the numbers don't necessarily tally because there are some recommendations along the way. So this convention talks about a number of things. Number one, it talks about the fact that member states that ratify must develop a national policy on occupational safety and health. Second, it talks about adopting legal policy and other measures at national level. So these are national level interventions. And then it talks about regulation to control what happens at the enterprise level, so where the employer and the employee are interacting. And then it makes a very brief mention that there must be coordination between the various authorities and bodies. That's Convention 155. And what Recommendation 164 would do in the context of accompanying a convention is it gives some detail, it fleshes out how different ways in which one can implement the convention, but without binding a member state. It's just ideas, this is how we can do things, because a convention is a very, very, it's a compromise between many parties and you can't include everything. So the recommendation allows for one to pick and choose how to go about doing certain things. Then we have the Promotional Framework for Occupational Safety and Health of 2006, and that's number 187. And it is accompanied by Recommendation 197, which is the Promotional Framework for Occupational Safety and Health recommendation. And it talks about 4 things. It talks about the fact that member states must adopt a national policy on occupational health and safety, or OSH. It talks about a national system for occupational health and safety. It talks about a national program on occupational health and safety. And it talks about a culture which is oriented towards preventing, preventative actions or preventative measures in terms of safety and health in the workplace. And these are the 4 things that the promotional framework aims to do. So if we were to look at these 2 conventions, we could say that the Occupational Safety and Health Convention really gives the nuts and bolts about what measures need to be taken to ensure that workplaces are safe and workplaces, do not present hazards and risks to the health of workers. And the promotional framework really speaks to the infrastructure, or the framework that makes it possible for us to implement those measures on occupational safety and health. So it's more like the nuts and bolts of the occupational health and safety system. And so the two they speak to each other and they go hand in hand. For example, where the promotional framework convention talks about a national policy on OHS, it cross-references. It must be a policy that complies with what is in C155. So what I'm going to do, I'm not going to go through each convention separately, but I'm going to look at these two main categories of interventions, as it were, and point out to you which ones relate to which convention. And I'm going to look at what is supposed to happen at the national level, and then what is supposed to happen at the level of the enterprise. And if we look at C155, as I said, it talks about this national policy on OHS, and C187 cross-references it. So both of them talk about this policy. And they say that a national OSH policy should address 5 spheres of action. So the one relates to the fact that in a workplace you have, there's a workplace, there's a working environment, there are tools, machineries, equipment, and so on. And all these things in the context of work and doing the work that one is doing need to be designed, need to be tested. There needs to be a selection of which ones. Sometimes they need to be substituted one for the other. One maybe that's safer. They need to be installed and arranged. They need to be used and maintained. So the material elements of work, how are these regulated and how are they introduced and controlled in the context of the workplace? The National OSH policy should talk about this. Second, it talks about the relationships between the material elements of work and the worker or the supervisor or both, and how it is that we can adapt machinery, equipment, working time, the organization of work, and work processes to the physical and mental capacities of these workers, right? So this is really dealing with the relationship now between the elements of work and the worker and the supervisor. Then it talks about the fact that the policy should ensure that there's training, including necessary further training, qualifications, motivations, and so on, for people that are involved in OHS, either as workers, as supervisors, as employers, and so on. There should be systems in place for these things to be dealt with. And then there should be communication and cooperation at all levels, from the work environment all the way to the national level. And the policy should also ensure, very importantly, that if, for example, a person is in the workplace and they do what they're supposed to do in terms of the National Occupational Health and Safety Policy. So let's say they say, well, I need PPE, and if I don't get the PPE that's required, then I'm not going to work. This is provided for in terms of the National OHS policy. Sometimes employers actually try to retaliate against such actions. And what this provision is saying, that there should be in the policy provisions that say workers must be protected from disciplinary measures where they were trying to act in accordance with the National OHS policy. I hope that's clear. One can't go into too much detail at this level. And then it talks about, C155 talks about other national interventions. One of them should be an enforcement system, which should involve sanctions for non-compliance. Typically, this is leveraged against the employer. And then the competent authorities should be able to carry out certain functions. So lots of things, regulatory things, involved in regulating OHS, determining which substances or equipment are prohibited, holding inquiries, accreditations, and so on. And then there are issues of the regulation of the design, the production, the import, and so on of machinery, equipment, and substances. So there must be maybe a body and a system that regulates all of these things, how these different elements of work are brought in and so on. And then there must be protection against undue consequences, which is also mirroring the provision that I spoke about, where one shouldn't be subjected to retaliatory action as a result of following OHS sort of protocols or removing themselves sometimes from the workplace because they are seeing that this is not how it's supposed to be. Sometimes employers want to cut costs, for example, and they'll take action against you for choosing to do things in a way maybe that imposes more costs on them. And then we have the promotion of OHS training in educational institutions. This should be something that's inculcated at all levels of education is what the convention says. And then it mentions this brief provision. There should be arrangements for coordination of authorities, which I would argue is part of what Convention 187 seeks to do. So then as we continue with the national level interventions, I'm going to go into Convention 187. And 187 talks about the national policy already we've talked about, and it really just replicates what is in or cross-references C155. It talks about a national system, and it calls this the infrastructure which provides the main framework for implementing the national policy and the national programs on occupational safety and health, which may be certain departments within the Ministry of Labor, for example. They may, in some cases, be located within the health ministry, but what are the different institutions, for example, that really play a role in implementing the national policy and all the programs and so on? Then it talks about a national program. So we talked about a policy, and the policy really will set out, what are the things that we want to do? What are the principles that we want to abide by? But the program now will include the objectives to be achieved, and it will include also a predetermined time frame and priorities and means of action. So this is oftentimes, you get these national programs that have a grid that's talking about, okay, we're going to do this in so much time, who is actually going to be doing this and so on. So it's more action oriented to really make sure that we get things done, we achieve what is in the policy, we make real those principles, or we realize the principles that we're trying to achieve. And then it talks more broadly about promoting, in the context of the national system, in the context of the national program, in the context of the national policy, a culture in which the right to a safe and healthy working environment is respected at all levels, where governments, employers, and workers actively participate in securing a safe and healthy working environment through a system of defined rights, responsibilities, and duties, and where the principle of prevention, so we're not looking at retroactive action if something happens, we're trying as much as possible to be preventative, and that must be the highest priority. So it's a culture, it's a way of doing things, it's a way of thinking, it's a way of operating, where the social partners are involved and where we have clear rights, we have clear responsibilities and duties, and prevention is key to that. Now, if we were to turn to what happens at the enterprise level, and this takes us back to Convention 155. Sorry, I didn't write it here. But what is involved now in terms of this convention is, number one, the convention requires governments to take national level actions, right? So this is government's responsibility to put certain systems and put certain things in place. Secondly, this convention is saying that there are certain things that need to happen at the level of the workplace. They need to happen at the level of the employer, and it's not always an employer, but I'll get to that, and the worker in the workplace. And what the convention says is that the government must put in place these measures. They could be legislative, they could be policy, they could be other practical measures, but they need to ensure that employers and workers are able to meet these obligations in order to promote health and safety in the workplace. So, number one is that there should be measures so that employers can ensure that the equipment, the machinery, the processes, and the substances in the workplace, in the work environment, are safe and they are risk-free or they are free of hazards. Secondly, there should be measures to ensure that employers provide adequate personal protective equipment. And I think COVID, more than anything, sort of really brought the issue of PPE to the fore. Then we have the issue that employers should have in place emergency and accident, procedures and protocols, including, first aid. What do you do if something happens? They should all those measures should be in place. And governments should also ensure that workers and representatives cooperate and are informed, they're consulted, and they're trained on OHS matters. And then there should also be measures to ensure that workers are not required to return to a workplace until remedial action is taken where a hazard has been reported. So if there's a faulty machine and it's likely that is going to, chop someone's hand off or something, and this is made known to the employer, the worker is entitled to walk away from the workplace until they know that this thing has been rectified. And there should be no penalty for them removing themselves from the workplace. And then importantly also is this principle that workers should not be required to pay for OHS measures. So, colleagues, these are the key sort of actions that governments are expected to take, or the measures that they're expected to take. And typically we'll find these in the context of a policy on occupational health and safety, legislation, acts of parliament, and including maybe regulations on occupational health and safety, and also programs that may be implemented and actioned by the government authorities. But the responsibility really lies with the government to guide workers, to guide employers about what they need to be doing in the context of the workplace. So I'm going to pause in a short while, but I just wanted to highlight the fact that if you look at these two conventions, in Africa, we have not a great, track record in terms of ratification. I think C155 is the better one. We have about 20 countries that have ratified. Funny enough, as I was searching, African countries that have ratified, some AI thing popped up and was saying almost all countries have ratified. And I was like, that cannot be true. So I went and I sort of tried to do a quick count. And so we have about 20 countries that have ratified Convention 155. 16 have ratified Convention 187. And this is, it has many implications because in the normal course of events, if a convention is not ratified by a member state, then it's very, very difficult to bring the weight of the the supervisory mechanisms to bear on them to promote compliance. But there are a number of reasons why Convention 155 and 187 and generally occupational health and safety provisions would still be brought to bear on member states. I can talk about this a little bit later in relation to the fact that now these two conventions have been added to the 8 conventions which were considered the core conventions. So since 2022, I suspect it was maybe an initiative or something that was pushed by the new Director General, who is African, Director General Hangbo, to include a healthy and safe workplace as one of the fundamental principles and rights at work. And so Convention 155 and 187 have now been added to those 8 conventions that relate to fundamental rights and principles at work. The 4 principles being, abolition of forced labor, elimination of child labor, addressing discrimination in the workplace, and discrimination. Hey, my mind is gone somewhere. I'll remember what the 4th one is. But forced labor, child labor, discrimination, and of course freedom of association and the right to collective bargaining. So because of the status that these conventions have, and what has tended to happen in African countries in the context of our, as the AU and within our sub-regional groups, there has been a great emphasis to say, okay, the ILO is the main body that deals with international labor standards. What can we do as African countries? And there was a big initiative around the issue of decent work and so on to get African countries to ratify the core conventions, the 8 core conventions at the time. And you'll find that when it comes to those 8 conventions, as African countries, we have tended to perform very well. And now that these 2 conventions have been added to the mix, it's likely that there will be a renewed push to say, let's not only ratify for those that have not ratified the first 8, let's also now ratify these 2 conventions because they are amongst the core conventions, and we would like to present ourselves as African countries as, aligning ourselves with these fundamental principles and rights at work and making sure that we are complying with these core conventions. So I think that, it's early days. It's only 2022 that this change has happened, but I think that there is a strong possibility that we may be able to move on this. So I'm going to talk a little bit about, in countries where these conventions have been ratified, where they haven't been ratified, what are some of the issues that arise, particularly in an African context? And for me, one of the key ones is that we are dealing with a labor market and a world of work that never really fit the mold of the context in which occupational health and safety regulation was designed. So if, it's talking about the union, it's talking about the employer, it leaves out in many cases, and it talks about, the assumption that it's large groups of people, many workers in the workplace. Oftentimes that legislation is at odds with the realities of most of the workers. 2/3 of the world's workers are in informal employment. And in Africa, that's closer to 3/4 or 80%, somewhere there. In my own country, Zimbabwe, we are looking at almost 90% of people are in informal employment. And so you have workers who are working, who are earning a living, who are providing employment, taking care of families, but who are not actually able to claim rights and protections in terms of occupational health and safety. I can talk a little bit maybe in further discussion about maybe how we can realize this, because it needs like a reconfiguration of things. But that is at odds with the way that Convention 155 has been interpreted by the Committee of Experts on the Application of Conventions and Recommendations, which says this convention talks about all workplaces, and that includes those in the informal economy. Then you have 187, and I didn't talk about this earlier, but 187 also very specifically says we must do as much as possible to take actions to promote health and safety in the workplace for workers in the informal economy. So already in these conventions, it's there. Already when we talk about occupational health and safety being part of the decent work agenda, and the decent work agenda in the ILO is very clear, that decent work is for all workers, regardless of their status, regardless of where they work, regardless of whether they're formal or informal workers or in informal employment. So already I think it's a big gap that we see. And because as African countries, we've inherited a system of occupational safety and health that is coming from the North, where the work environment was different, and it's changing even there. we have not really evolved fully to embrace other forms of work. Then the issue of the changing world of work. So even for those that are in the formal sort of employment, there are all sorts of things that are happening. There's subcontracting, there's labor broking or temporary employment services, which are not temporary. There's teleworking, there is homework. So people that are producing for a factory, but in your own home, and then giving it to the person who's contracted you to do the work. There's platform work. How do you bring in the Ubers? How do you bring in the sweeps outs? How do they factor in to this equation? There's been a big uproar. I don't know if Jackie is here, but there was a big issue around those moderators who were, is it Facebook that contracted a company in Kenya to bring in moderators to moderate the content. And there's all sorts of triggering things that they see. And now who's responsible for taking care of that? Because they are not contracted directly with Facebook, and probably they are called independent contractors. How do you deal with those kinds of things? And how do you deal with the fact that they're working in their own home? There are so many things that we need to think about. And then the recognition of risks such as mental health, harassment, and violence in the workplace. These are things that haven't traditionally at the national level in our legislation been recognized and acknowledged as health and safety hazards. How do we regulate them? Particularly because some of them can be a bit more subjective than the objective. There's a machine, there's a chemical, there's this. How do we actually wrap our heads around those kinds of risks and ensure that workers are protected without accusations that this one is overly sensitive, I didn't mean that, I wasn't harassing you, and all those things. And then I'll talk about just the challenges in relation to resources, the frameworks for labor administration and infrastructure. This is a problem that we have in African countries. We're just under-resourced. And, if you look at the Department of Labor, if you look at the inspectorate, if you look at the health and safety offices, and you look at the staffing and capacity also to be able to be alive to these new changes, particularly where they're operating in a legal framework that is sort of cemented in a time that's not as relevant, in a place that's not as relevant as in Africa. Those are challenges that we experience. So I think I'll stop there and leave it to my esteemed colleague to take it further, and then maybe in discussion I can address a number of other aspects. Thank you.
Thank you so much, Dr. Bamu, for that very good summary. I think you highlighted the key provisions, which is very, very useful. So thank you for that. So to sort of drive the conversation further and make this as interactive and engaging as possible, I would start with some questions. And I'm going to be starting with Mrs. Wosu, right? So just like Dr. Bamu had said, these conventions speak about, having a policy, right, when it comes to OSH issues. And thankfully, Nigeria has ratified both conventions. In fact, for the Convention 155, Nigeria has ratified it way back. I think it's been a while. I can't remember the exact year now, but it's sort of been in operation for maybe about over 20 years, more or less, right? So that's for Convention 155. And then for Convention 187, of course, it was a recent convention, right? So you find that it came into force, I think it was 2009, and then you find that Nigeria ratified it in 2022. So that's about 2 years ago. So that's fairly new. But again, there's some sort of commonalities between both conventions. So Nigeria has ratified both convention. Looking at the objectives, the broad objectives of the convention, can we say from a policy standpoint that Nigeria has been able to, meet the objectives, which is, can we say Nigeria has fared well when it comes to formulating, implementing, and having a coherent national policy on OSH issues?
All right. Thank you very much, Adiola. First of all, I want to extend my appreciation to ELAN, the African Labour Law Society, ALLS, and ILAW for inviting me to speak at this webinar series. I'm truly honored to be here. I've listened to Dr. Bamu, and I must commend her on the generous presentation that she's given on the ILO conventions. She's spoken explicitly on the topical issues being Convention 155 and 187. And she's raised so many points that I believe that we're going to thrash out during this discourse. And I've noted issues that I'm very passionate about. So basically, work influences a person's physical, social, and mental well-being because we spend more time at work than we spend with our families and at home. So it's important for stakeholders, social partners, and relevant institutional bodies to engage in these conversations and increase the awareness of occupational health and safety in the workplace. My job focuses on employment injury benefits for the Nigerian workforce, and I've interfaced with hundreds of employees, employers, and families that have been affected by occupational contingencies in Nigeria, such as disabilities, injuries, death. I've witnessed the impact that the lack of compliance with OSH standards in this society has on these families. And it's very heartbreaking to know that these contingencies could have been avoided if stakeholders as a whole complied with basic OSH international standards. So I'm very interested in this topic. Speaking from the Nigerian perspective, I would break it down into maybe two segments. First being compliance with formulation of policy. So in terms of policy development, I would say that Nigeria has made significant strides in formulating the national OSH policy, but it's still a work in progress. Why? There is no national legislation covering occupational health and safety in the country. So the implementation of occupational safety and health in Nigeria includes the totality of all legislations, policies, activities, and programs that are engaged in to attain the minimum standards of the OSH conventions. Firstly, we have the national policy on labor, which is based on the provisions of Section 17 of the 1999 Constitution. And it provides that the state shall direct its policy towards ensuring that the health, safety, and welfare of all persons in employment are safeguarded and not endangered or abused. So, like you stated, the federal government has ratified Convention 155, that was in 1994, and Convention 187 very recently. There are other conventions that Nigeria has ratified. We have Convention 32, which borders on the protection against accidents, dockers, of 1932. And then we have Convention 19, which borders on equality of treatment, accident compensation of 1925. So these are other occupational health and safety conventions which Nigeria has ratified. And Convention 19 has actually been domesticated into national legislation by the enactment of the Employees Compensation Act of 2010. Furthermore, we have the National Policy on Occupational Safety and Health. And it's basically Nigerians' response to her ratification of Convention 155. The policy came into force in November 2006. Is to be reviewed every 3 years to ensure that it remains relevant and effective. and it provides a framework for OSH regulation and sets out the responsibilities of stakeholders, including government agencies, employers, and workers. The objective of the policy is to create a general framework for improving working conditions and the working environment, to prevent accidents and departures from health arising out of the course of employment. It's to ensure the provision of occupational safety and health services to workers in all sectors of the economy. So the scope of the policy covers both the formal and the informal sectors of the economy, and ensuring that the protection of all categories of workers from occupational contingencies. So the policy provides guidelines to cover the prevention and control of hazards from all forms of occupational exposure. It provides provisions for health surveillance and emergency medical services. It provides provision for training in the area of occupational health and safety, and also provides for the gathering and storage of information pertaining to occupational safety and health, amongst other areas of focus. So the policy is basically the blueprint for OSH standards in Nigeria. But as I stated earlier, Nigeria does not have a holistic and contemporary act or legislation for occupational safety and health. Even though there have been attempts to enact one, I'm aware that there's the Occupational Health and Safety Bill that's currently before the National Assembly, and it's been before the National Assembly since 2012 and has not been passed into law to date. Ultimately, the policy is supposed to strengthen the national labor policies and extant labor legislations and provisions. But if we don't have this, how do we move forward? How do we move forward? So what happens is that we rely on various legislations. There's so many legislations out there in the country. And we have a few that have been enacted to provide for the safety and health of the workforce. The main act for occupational safety and health in Nigeria is the Factories Act of 2004. We also have the Employees Compensation Act. That is for compensation for employees that have incurred occupational contingencies. We have the Nigerian Minerals and Mining Act. We have the Nigerian Nuclear Safety and Radiation Act. Then we have other related acts. Not majorly, they're not really health and safety acts, but they just have bits of provisions for health and safety. We have the Nigeria Basic Ionizing Radiation Regulations. There's so many legislations. We have the Lagos State Safety Commission law, which is confined to Lagos State. So you see, all these laws that I've mentioned were enacted to regulate occupational health and safety in a specified segment or sector in the economy. So for instance, the Nigeria Minerals and Mining Act was enacted to regulate aspects of solid mineral exploration in Nigeria. And then we also have the Nigerian Electricity Management Services Agency Act, as NEMSA, that was enacted to ensure the delivery of safe and reliable electricity power supply in Nigeria. NEMASA, that regulates maritime workspace. So we just have all these laws that they are more or less everywhere. They're all over the place, and this just the impact is that most employers, that's mostly multinationals, naturally adopt the Convention 155. And then we also have ISO 4500, which are global standards for occupational health management systems. But these are international conventions and standards concerning OSH, and it makes it difficult to enforce breaches of occupational health and safety in Nigeria, because we haven't domesticated them into national legislation. So the National Industrial Court really has no choice but to draw from the ILO conventions to fill up this gap when adjudicating on cases that concern occupational safety and health. And for me, I believe that we need to bring these laws together into one single national legislation that suits the peculiarities of the Nigerian terrain. We have the national policy mandates the Ministry of Labor and Employment to take responsibility for regulating the work practices and work conditions of organizations by way of implementing the safety, the health, and the welfare provisions of the Factories Act. So most SMEs and OSH practitioners in Nigeria rely on the Factories Act when implementing OSH arrangements in their respective workspaces. And as I stated earlier, larger corporations have developed their in-house industry-specific management systems that enable them comply with statutory laws within Nigeria and that of their parent country, which are mostly international organizations bound by their global organizational OSH policies. So, the challenge, first of all, is with the Factories Act, which is the current law on health and safety in Nigeria, but it's limited in its application, and it's no longer suitable for contemporary Nigeria. I mean, the peculiarities of work in Nigeria have changed. Health, safety, and environment has evolved and expanded. So safety cannot be confined to factories only. Safety is necessary in all sectors, including corporate Nigeria. And it has even transcended to remote work. So we've evolved to safety in corporate Nigeria, remote work, and it's become obvious that the Factories Act is no longer obtainable and effective. So in the absence of a national law, and you combine it with the ineffective laws that we have on ground, the workforce just has to rely on OSH provisions that are spread out in the various laws, using the national policy as the minimum standard of OSH.
All right. Thank you. Thank you so much. I mean, I hear you, which is that we have a lot of fragmentation happening, right? That you have bits and pieces everywhere and in different sectors, rather than having a comprehensive legislation that deals with these issues. And then the other issue is even the seemingly comprehensive legislation that we have, which is the Factories Act, is outdated. So let's hope that we have some policymakers on this call, and maybe we would get some reprieve as we go along. But thanks a lot for that response. So now moving to Dr. Bamu. During your presentation, you had touched on the point that there's the ratification level of the OSH conventions amongst African countries is very low. Not. I mean, it could have been better, right? So considering that low level, what would you consider, and the fact that health and safety is such an important thing and an important feature of work, what are the implications for workers in African countries that are yet to ratify these conventions?
Okay, thank you. Thank you, Adiola. I think, so number one is I talked about the fact that these conventions are now part of the core conventions because a healthy and safe workplace is now a fundamental principle and right at work. And the implication of that is that in terms of the 1998 Declaration on Fundamental Principles and Rights at Work, all ILO member states should work towards promoting these fundamental principles and rights at work, regardless of whether or not they've ratified, because these are coming from really the constitution of the ILO. These are what are non-negotiables, as it were, in terms of being a member of the ILO. And because of that, as a person who signs on to the constitution by becoming a member, you are basically saying that you're going to do the best that you can to actually promote these principles. So number one, I think I mentioned already that in Africa, we have a commitment to promoting these principles. And I think it's a matter of time before we catch up. That's the African context. But further to that also, because they are fundamental principles and rights at work, there is an obligation for even countries that have not ratified these rights, these conventions, some of these conventions, to report periodically to the supervisory mechanisms to say, okay, well, we haven't ratified this convention, but this is what we are doing in relation to that. And it's then up to the follow-up mechanism on these fundamental principles and rights at work to make some kind of a determination as to whether there can be some support that's provided to member states, because is there a word called fundamentality? But the fact that these provisions and these principles are so fundamental warrants that action be taken to promote them and to realize them, whether or not countries have ratified. And I think that, in the context of the ILO being a body that, doesn't impose those direct sanctions, there's something about the shaming effect, when you're mentioned in certain reports, you don't get a very good review. There's something about that sometimes governments are, try to avoid by actually cooperating. And the ILO itself then lends, we'll provide technical cooperation, we'll provide the support that you need to actually align yourself with these conventions, even if you haven't ratified. So I think the status as a fundamental principle and right at work in the African context and generally in line with that framework already puts us in a position where we are likely to start to see a little bit more movement in Africa. Then the other thing I think is the decent work agenda, which, one of the pillars, there's social protection, or there's sort of work and employment opportunities, there's rights at work, there's social dialogue and social protection. And rights at work fundamentally includes occupational health and safety. And, it's decent work for all workers, regardless of where and so on. And it's not just a mantra or something that, people say decent work, decent work, decent work. But what the ILO did to operationalize it is to say that within each country context, we are going to develop decent work country programs. And regionally also there are decent work country programs. Africa has a decent work country program. And this is where this issue of ratification of core conventions also came from. So if we have the decent work country programs, which are not imposed by the ILO onto a country, but are the product of social dialogue, a product of employers there, government there, workers there, facilitated by the ILO, this is a space within which countries now identify these are some of the challenges we are facing. These are some of the priorities that we should be working towards. I would love to see, I haven't looked at the Nigeria's Decent Work Country program, but I would imagine an issue like occupational health and safety features there. And how do we action it? How can we actually take it forward? Looking at the context, looking at the priorities, looking at what's possible and looking at what can be actionable within a particular space of time. So the decent work agenda, besides like nice language and something that people throw in everywhere, is actually something that the ILO has a mechanism to ensure that it's now streamlined into programming, streamlined into work that's being done around labor. And it could be, for example, that Nigeria could say, one of our priorities is we want to pass this OSH bill. And how do we take action to do that? That could well be something that is in your decent work country program. So yeah, there's that. And then if we also look at internationally conventions like the International Convention on Economic, Social, and Cultural Rights, which many African countries have ratified, also talks about the right of everyone. So not every employee or every worker, but the right of everyone to a safe and healthy workplace. That also imposes certain obligations, which through the supervisory mechanisms of that body could also be brought to bear on that. So I think that all hope is not lost. It's not it's something that's so fundamental and basic, but it's something that doesn't receive the kind of priority that it should receive. I think at the international kind of level, there are different mechanisms through which these principles can be brought to bear on member states. Thank you.
Okay, thanks. I'm sort of mindful of time, but I just wanted to quickly ask a follow-up question to that, and if you could just answer it very quickly, because we still have to create some time for questions from the audience. So the other thing, even though you had also touched on it, but if you could just expand a bit more on that, is the question of informal workers, right? That the convention sort of, when you look at it and read it literally, it sort of suggests that it should cover only those that are in formal workspace. And then, of course, in the African context, you have a lot of people working in the informal workspace, right? So again, how do we realize the objectives of the convention in this context, in the context of those working in the informal work setting? If you could just answer that maybe in
okay. So very
5
quickly,
minutes.
I'll give a little example. And yeah, literally 155 doesn't. But it's interpreted to include, and then 187 is very literally, is very explicit on that. And I think recommendation 164 also refers to informal. But anyway, if we look at what happened during COVID, right? We did a review, my colleagues and I at WIGO did a review of about 41 African countries and 7 Asian countries. And we looked at what kinds of, the laws that were passed during COVID. The big one of the big ones was around occupational health and safety and protections in the workplace. And what we saw, obviously, there were protections for workers in the formal economy. But there was a recognition, for example, in the context of street vending, that there needed to be measures put in place to protect workers and to protect the people that interact with them in those settings. And amongst those kinds of principles were the fact that local authorities must provide for access to water. They must provide for sanitation, stations. They should provide for cleansing. They should provide for access to the workplace to be controlled, to ensure that maybe people don't come in if their temperature is above whatever. There should be training and education of workers within the context of the workplace. So if we look at that, it's giving us already some of the signals and some of the signs that, for example, if you look at the street vendors that are operating on a public space, it's controlled by local authorities. Within the context of COVID, there were directives to say, local authorities must do this. Local authorities must consult the workers. That's already social dialogue. That's already including them in discussions about health and safety. So it's a question of how do we think creatively, looking at the work context, looking at the type of work that is being done, looking at who the stakeholders are in that context to be able to address the issues that come into place. Because these protections and provisions I'm talking about were requiring that local authorities provide, meaning that they also pay, even though they are not employers, but because they control that particular workplace, that those measures should be taken into place. Another one, for example, with domestic workers, we can't have the type of industrial regulations that regulate that work in a context where someone is working in that private, intimate space. We need to then think about what are the specific rules, what are the specific things that need to be done for one to be able to understand and to know what to do to protect health and safety in the workplace, and how do we create opportunities for workers and employers to engage on those issues, even if it's on a one-on-one basis, which is not provided for in legislation. So I think it's about creativity, context, and really intentionality in saying, how can we extend these kinds of protections to these workers?
All right, thank you. So before we move to the participants, I just have one final question for Mrs. Woso, and then we can open the floor to questions from participants. So Mrs. Woso, the other question that I had was, and considering your experience is, can you explain the impact of the convention on employee injury benefits? Mrs. Woso. Okay, maybe we come back. For some reason, our video is off and the mute button is also on. We can always come back to that. So whilst we come back to that question, I would...
Hello.
Okay.
Hello, sorry.
No, it's fine.
So please, can I get the question again?
So the question is, and just before we move to the general floor and ask people for the questions, the last question that I have for you is, and considering your experience as well, can you explain the impact of the convention on employee injury benefits?
Oh, okay. Okay, so worldwide, employment injury schemes provide three main functions, which are fundamentally prevention, to reduce the number of workplace accidents and diseases in the workplace. Then we have rehabilitation, so that individuals affected can, if possible, return to work. And then we have compensation, where individual workers have lost out on earnings. So a modern employment injury benefit scheme would be based on the combination of preventive and protective measures, proactive accident prevention to minimize sole dependency on the employment injury scheme, and basic economic security for the victims in a crisis situation. So there's a close connection between prevention, rehabilitation, and financial compensation. And it's of fundamental importance and should be made clear to the parties involved, particularly employers, that capital investment in workplace safety pays off, primarily in humanitarian sense, by preventing human suffering, but also in an economic sense. That is through the reduction of accident insurance premiums and company costs resulting from injuries. Employers must be aware that they remain responsible for the health and safety of employees in the workplace. So even though the direct liability to the employee has been replaced by the employment injury scheme, the responsibilities of government, of the employers and workers should be seen as complementary and mutually reinforcing to promote occupational health and safety to the greatest extent possible, in line with international best practice. For NSITF, we started vigorous occupational safety and health audits in 2017. HSE officers were mandated to collaborate with the Federal Ministry of Labor and Employment to conduct inspection exercises. And I can tell you for a fact that there was significant reduction in accident reporting within that year. So I'm aware that a particular organization that reports accidents at least twice to 3 times a month on the average. Once the HSC department kicked off on their OSH audits, they conducted an inspection on this employer, and the number of accidents reduced drastically. So currently, in the last 2 years, they've only submitted an average of 2 accident notifications, which is a very great improvement. So that shows that there's actually an impact. Employment injury benefits is not just about compensation. Prevention is very key and very important, and it goes to show that implementing Convention C155 and 187 has made an impact on our accident reporting in Nigeria, and has consistently minimized the cases and causes of hazards inherent in the working environment. And this, in effect, has reduced the costs associated with work-related injuries and disease. And it's also contributed to the improvement of working conditions and the working environment. Yeah.
Okay. All right. Thank you. Thanks a lot. So now we can open the floor for questions from the audience. If anyone has questions, you can either type them in the chat box or raise your hands, and then I can call on you to ask the question. Okay, does it seem like we have questions? I suppose maybe we've sort of covered the areas that people may have otherwise. Okay, just a question just came in, and I think that's for Mrs. Wosu. So the question is anything being done to review the compensation rates for injury under the ECA in view of current economic realities?
Can you hear me?
Yes, we can hear you.
Yes. Yes, we understand that the current economic realities are really tough. And yes, the fund has actually proposed reviewing the act. We're actually doing that right now, trying to review the act, and because there's so many lapses, there's so many gaps in the act that need to be filled, and that's basically one of them. But to be fair, the fund guarantees adequate compensation to employees. Why am I saying this? Compensation is based on the salary of the employer, of the employee. So for instance, if an employee earns 100,000 naira, the employer is expected to pay 1% of that salary to the fund. And that fund is to be used to pay compensation when that employee incurs a medical contingency. So in the case of, let's say, death, an employee that earns 100,000 naira a month is entitled to up to 90%. That's the family is entitled to up to 90% of the employee's salary. And 90% would be 90,000. I'm just trying to break it down so that people understand that it's actually a fair process of compensation, because it is based on your salary, the salary that your employer pays you. So 1% also cuts across for those that earn higher. So you find out that we have employers that pay maybe $1 million to a certain set of staff. 1% of that would be much higher. You would get 100,000. While 1% of 100,000 would be 10,000. So that's basically what it is. But I know that there are proposals because we're currently fighting for minimum wage right now. So, it's understood that people agitate for change in various legislations. And the ECA is also part of what is going to be reviewed. Thank you.
All right, thanks. The other question is this national policy on labor. I don't know, someone says they can't find it. What's the full name? You had mentioned it during your discussion on one of the things that touches on OSH. Okay, whilst you look for it, Ma, Dr. Bamu, there's a question for you. I don't know if you can say it. It's a bit long, but is this something you can say and maybe attend to?
I can see it, and it's the one that I was talking about in terms of the fact that elevating occupational health and safety to the level of fundamental rights and principles at work is a big game changer, because unless you are there are some countries that just don't really ratify conventions, even the fundamental ones, but for most countries it's important for them to do this, to ratify, and to be seen to be ratifying, to be seen to be complying. So I think there's already a natural gravitation that it would take. So the 8 can I list them here? But they're like, if you just go into that, there's for child labor, I think it's the minimum age convention, the worst forms of child labor, and then with collective bargaining and the right to freedom of association, there's Convention 87 and Convention 98. Now I won't remember off the top of my head the titles. And then there's for discrimination, there's the Discrimination Convention, and I forget what the other one is called, but I think one of them is 111. And then for forced labor, there's the Abolition of Forced Labor Convention, and I can't remember the other one off the top of my head, but they relate to those 4 principles: forced labor, child labor, discrimination and freedom of association, and the right to collective bargaining. If you just type core conventions of the ILO, they'll come up quite quickly. So yeah, elevating it to the fundamental rights and principles is a huge game changer. And even if they're not ratified, as I said, the mechanism that the fundamental rights and principles sort of put in place to avoid a situation where, you just have a declaration and everyone says, yeah, there's a declaration, and people mention it as and when, is that it has the requirement that countries that have not ratified, I think it's every 3 years or every 5 years, there's a check-in. What have you been doing? Report on how you've been implementing the principles of these conventions. And coming out of that, then they've put funding into taking action further, where they see, okay, here there are like some big gaps, here there's a great need for X and Y and Z. Then the technical support, the technical cooperation of the ILO kicks in to be able then to support member states to actually do something, to bring their laws, to bring their policies in line with that. And I think that makes a big difference. It's not there's no sanction, but I think there's some support that can be provided. And I think in the context of, submitting reports periodically over time, there's an expectation that you demonstrate that from the last time we reported, we've done this. Now we've got this in place. So there's also that natural sort of desire and drive and motivation to actually make improvements in the periods in between the reporting from one reporting cycle to the next.
Okay, thank you. So we'll come back to you, Stanley, on that whole law. We'll come back to you. So this brings us to the end of the webinar. It's been a very fruitful and useful discussion, and we thank our panelists for their time. So I would now hand over to someone in Helen for the formal vote of thanks. And thank you to the audience as well for joining and staying to this time. Thank you.
Good evening, everyone. So on
Hi.
behalf of good evening. So on behalf of Ellen, we want to express our sincere gratitude to everyone who have joined the enlightening webinar today on speaking on review of Convention C155 and C187 on health and safety work. We want to say thank you to our speakers. Thank you for making our time to be part of this webinar today. It's been an enriching experience and it's filled with insightful discussions and valuable takeaways. So we'll say thank you, and we'll invite you on our next webinar, which is next month, to also join on another talk of this series. Thank you very much.
Right, thank you. Bye, everyone. Have a great evening.
Thank you very much and take care, everyone.
Thank you all.
Thank you very much. Please, is there any way we can get the slides?
Tobamu.
I will share them with the organizers so that we can cross-post them with the, I think when the link to the recording is shared.
Oh,
all right.
okay,
Thank
you.
you. Thank you very much.
Thank you, Dr. Bamu. Always very, very helpful.
Most welcome. It's just like the worst week. I had visitors and then something to submit, but thankfully it worked out for me to be able to participate and to bring something to the event. Thank you.
You're welcome. Like we say in Nigeria, we always say a day body. So once you have you don't need much preparation, really. It just comes flowing.
For sure.
Thank you very much. Thank you. Bye.